Welcome to today's discussion on Aquinas' theory of law, a philosophical framework that has shaped legal and moral thought for centuries. If you have ever wondered about the connection between law, morality, and divine justice, then Saint Thomas Aquinas offers one of the most influential perspectives. In this session, we will explore who was Thomas Aquinas, his definition of law, the four types of law he proposed, the connection between law and morality, and criticism and contemporary relevance. So, let's begin. Who was Thomas Aquinas then? Thomas Aquinas was a Catholic philosopher and theologian from Italy who lived between 1225 and 1274. He was deeply influenced by Aristotle and sought to reconcile Christian theology with a rational philosophy. He develops his theory of law in his most famous book, Summa Theologica. Aquinas believed that law is not just a set of rules, but it is a system grounded in reason and morality. He argued that true law must align with a higher moral order, something that reflects both natural reason and divine will. So, what is law according to Aquinas? Aquinas defines law as an ordinance of reason for the common good, which is made by him who has care of the community and promulgate it. So let's break this definition down. What is meant by ordinance of reason? This means law must be based on logic and rationality and not on personal whims. Second thing, law must be for the common good, which means laws should benefit society as a whole, not just a select few. Thirdly, it must be made by proper authority. Only legitimate rulers or governing bodies can create laws. And finally, promulgation means laws must be publicly known and enforced. Now that we understand his definition of law, let's move on to his fourfold classification of laws. So the four types of law Aquinas categorizes, each plays a distinct role in guiding human behavior. The first category of law is eternal law. This is the divine wisdom of God that governs the entire universe. It is unchanging and reflects the ultimate order of existence. It does not change. Everything in nature follows this law, whether it's the planets orbiting the sun or the biological processes of living beings. The second law is called the natural law. This is the human understanding of eternal law. Aquinas believed that humans, by using reason, can discern what is right and wrong, do good. This is the basic principle of natural law. Why he's saying? Because human being is empowered with reason. And with the help of reasoning ability, man is capable of doing good and avoiding evil. For example, humans naturally understand that murder and theft are wrong. These moral principles exist independent of written laws because they are part of human nature. Third law is human law. These are man-made laws which are created by governments to regulate society. So under these laws against theft, murder, or speeding are all covered. And these are the examples of human law. But here is the catch. Human laws must align with natural law. If a law is unjust, for example, law that legalizes slavery, Aquinas would argue that they are not true laws at all. The fourth category of law Aquinas gives us is divine law. Since human reason is limited, God also provided divine law through religious texts like the Bible, the Quran, and the Vedas. Divine law guides humans towards salvation and moral perfection. For example, while natural law tells us that murder is wrong, divine law might tell us how to seek forgiveness for sins. So what is the connection between law and morality? Remember that according to Aquinas, faith and reason can coexist. For Aquinas, law and morality are inseparable. Laws must be grounded in justice and ethics. If a law contradicts natural law, then it is not a valid law. For example, if a government enforces a law that follows or that allows discrimination, it is unjust because it violates natural law. This idea has influenced modern legal thought, especially in debates on human rights and civil disobedience. Think about Mahatma Gandhi's non-violent resistance or Martin Luther King Jr.'s fight against racial segregation. Both argued that unjust laws must be opposed because they violate natural moral principles. All right, so with these four categories of law, we come to the last part of Aquinas' contribution to theory of laws and his contemporary relevance. Aquinas' theory, however, is not without criticism. Some scholars argue that his reliance on divine law makes the theory too religious. Why? Because in a secular society, should laws be based on religious morality? That is the question. Second thing, what about cultural differences? Natural law assumes universal moral principles, but different societies have different moral codes. So, what to do about that? Third thing, legal positivists like John Austin argue that law is simply what is imposed by the state, regardless of morality. So they believe laws don't have to be just, they just have to be obeyed. However, despite these criticisms, Aquinas' theory remains highly influential in debates on human rights laws, the morality of war, that is just war theory, ethical dilemmas in medicine and technology. So these are the reasons that Aquinas matters today. To sum up, Aquinas saw law as a rational guide for the common good. His four types of law, that is eternal, natural, human, and divine, help us understand the hierarchy of laws. He argued that unjust laws are not true laws. His ideas continue to shape debates in ethics, governance, and human rights. So, the next time you hear someone say this law is unjust, remember Aquinas. It's not just about following the law, but about ensuring that the law is just in the first place. Thanks for listening.